Did you know using images of the Eiffel Tower like this one is okay, but posting images like this one in the United States could land you in hot water for copyright infringement? What's the difference? The obvious difference is a daytime version and a nighttime version, but there's more to it than that. About 150 years ago, Gustave Eiffel began construction on the tower that would later take on his name. Construction was completed in 1889. Oddly, at the time, the Eiffel Tower itself didn't receive copyright protection. As an architectural structure, it wasn't considered an artistic work for copyright. Luckily, Mr. Eiffel had his designs and blueprints drawn out. Those were considered artwork and received automatic copyright protection. Back in those days, copyrights were automatic because the French didn't have a government office to register copyrights like the United States. Under Old French law, copyrights lasted the life of the author plus 50 years after his death. Gustave Eiffel died in 1923, meaning his designs expired in 1973, so the public had free access to the Eiffel Tower's image since that time. It wasn't until 1997 that France and the European Union finally passed laws to give copyrights to architectural works. Those laws also extended copyrights to 70 years after the author's death. Those rules were retroactive, meaning they applied to past works, but that didn't help the Eiffel Tower, because the extra 20 years only extended its copyright to 1993, 4 years before the new rules even took effect. Then, how is it that we can get hit with copyright infringement for using nighttime images of the Eiffel Tower? It's because the tower got new copyrights for its light arrangements and nighttime silhouette starting in 1986. That was when French light engineer Pierre Bidoux added the new light design to the tower. He only recently died in 2021, so the image of the Eiffel Tower at night gets copyright protection until 2091. But wait a minute, why should Americans living in the United States care about French copyright? Actually, it's not about the French law, but about American law, because the company that owns the Eiffel Tower registered the copyrights here in the United States. That company, which goes by the French acronym SETI, could sue Americans in U.S. courts for copyright infringement. Of course, that would be a public relations nightmare for the city of Paris, who doesn't want to scare tourists away from taking pictures with the Eiffel Tower. So SETI made it publicly clear that only professional, commercial use of the nighttime images would require authorization. The rest of us are free to share our memories of the Eiffel Tower with friends and family. It goes to show that public opinion can sometimes change the way copyright holders enforce their rights. If you like stories about patents, trademarks, and copyrights, or want to learn more about getting one, like and subscribe to get access to even more content. And if anyone asks, where'd you learn this? Tell them, it's my idea.